everyone. Victoria Lozano here, attorney and founder of Plan Forward Legal. We are an estate planning firm. We also do probate and trust administration. Today, I am here to talk about revocable trusts. I'm going to be very simple about it. And today, I'm just going to talk about an individual as opposed to a married couple. So this type of revocable trust structure is particularly for a single person, or it can be a married person with separate assets. So that could mean if you were married later in life and you have assets from before the marriage that are legally not considered interwoven assets. So it would just be years prior to the marriage and doesn't end up getting mixed in with the marriage afterwards. So a revocable trust, sometimes called a living trust, are contracts that are made while you're living that are enforced when you die. A revocable or living trust allows you and labels you as the grantor or the settlor to remain having control over all of your assets, but instead of these assets being in your name, they will be retitled as your trust name. Now, there are caveats and nuances to that, but I won't be getting into that today. I'm just giving a very simple kind of overview. So I have drawn out a very, very elementary picture here, but I do want to show you a drawing of what a trust looks like. So you can see here, these are your assets. Okay. There's a house, there's a bank account, trust account, bank accounts, investment accounts, money markets, and there's vehicles. So these assets all have titles. I would say bank accounts, not included retire accounts such as IRAs or 401ks. Those all stay in your name, but other accounts can be indicated differently. So your house has a title to it, your cars have title to it, your money has title to it. So what we do is we create a trust. This trust is a contract that you make while you're living and is enforced when you die. So you are the grantor and settlor of your trust, but when you die, whoever you assign as the successor trustee will then be in charge of the trust. Does not mean that they own everything in the trust. Nope. They are just in charge of administering what is the instructions of the trust. So down here you see B1, B2, B3. These are meant to represent your beneficiaries. So in the contract of your trust, you have specific instructions on how you want these things up here to be distributed to your beneficiary 1, beneficiary 2, beneficiary 3. Now, there again, right, are nuances and caveats depending on the age of your beneficiaries. You can create a whole host of instructions, but for simplicity reason, we're just going to pretend that all these beneficiaries are adults. So have an individual, you are the individual, we'll call yourself the individual trust. And in the individual trust, you have set out instructions for your administrator, AKA your successor trustee, to give 1/3 of the total value of your estate to B1, 1/3 to B2, and 1/3 to B3. So you pass away. Your individual trust, which was revocable while you were alive, is now enforced and is now an irrevocable trust, meaning it cannot be altered or changed. So whatever instructions you had set forth will be executed by your administrator. Your administrator has to take account for everything in your estate. So the value of your house, the value of all your accounts, the value of your vehicles, the value of any jewelry or art or anything of, big value in your house. They partner up with a CPA and they They create this whole estate value, and it is up to the administrator to get an accurate value and then distribute 1/3 to each of the beneficiaries. Many questions I get are, how do I know the trustee is going to do this? Like, how do I know my administrator is going to administer? Trust administration is a lot of work. It is not easily done, and more often than not, the successor trustee, the administrator, has to partner up with an attorney and or a CPA. Sometimes a tax attorney can kind of handle both, or an attorney with a CPA license can be both those people. So typically, there is some type of attorney involved in the administration of the successor trustee has a fiduciary responsibility. So, fiduciary means that you have a legal obligation to distribute to the beneficiaries. The beneficiaries also have legal rights for, according to the Universal Trust Code, they have rights to request accounting from the administrator, to request copies of the trust document, to essentially kind of contest if they feel like there's something going wrong. They may not be able to, for example, I know many attorneys have a no contest clause within the trust. And granted, what that means simply is a beneficiary who was, expecting $500,000 is only getting $100,000. They can't argue and say, but I expected to have this much, because if they argue, then they lose even the $100,000 that was given to them. What I'm suggesting is a beneficiary notices that the administrator is not, or is withholding money, is creating fraudulent statements, is acting shady. They can sue that administrator, and the administrator may be at fault personally. So there are legal avenues that one can take, and that tends to ease any nerve that my clients may have about, well, here I am creating these wishes, but how do I know they're going to be implemented? And also, when you work with an attorney, they the attorney should be asking you questions about the trustworthiness, the age appropriateness, plan A, plan B, plan C of people that could administer the estate. And it's also why we know that estate plans change. Whoever you allocate and choose in your 40s may not be the same people that you choose or allocate to in your 60s. So these are all kind of fluid documents. Again, until the person has passed away, and then they are sealed tight shut. No changes can be made, and then it's enforced. So a part of your attorney's job in creating this trust for the individual is helping them fund the trust. Essentially, if you were to create a trust, that contract, and then you died, that administrator has to take the value of all the assets. But if those assets are not titled correctly, or not titled to the trust, and are still titled in the deceased's name, then that contract doesn't really mean anything. The grantor can't get access to that value. So the alternative then is to go to probate court, which defeats the purpose of a revocable trust. So a revocable trust, a living trust, helps avoid probate court, which keeps it nice and private. But you have to make sure that your assets are titled to the trust. So there's steps that you have to take. And that's why it's important to have an attorney's guidance through this process. So I'm just going to stop my share. So a revocable trust, here are some pros and cons. The pros, it's a private contract between you and your beneficiaries. You get a lot of freedom on where you want your stuff to go. You also get the freedom of privacy with renaming your assets. There's also somewhat of an added layer of creditor protection once you pass away, not while you were living. That's a different type of trust that can do that. The cons of a revocable trust are: one, they're only valid if done correctly. Two, they don't mean anything if they aren't funded correctly. Three, it is more time consuming to create than just a basic will. For example, I had a client who was on her deathbed, and I tried my hardest to get everything done within 1 week. Even though we were able, at the time, we didn't know it was going to take 1 week, right? We thought we had some time. I was able to get some documents set up, but we weren't able to execute the funding. So we were then having to go and are currently, going to probate court. The cons are really about how you're executing this trust, who you're using to help organize and plan and strategize the trust, and making sure you have enough time to do so. I talk to a lot of people, and usually the people who have transformed their financial situation, they have started out maybe in really modest means and have since then grown into the millions. Many of them, and this might be you I'm talking to, many of you have worked really, really hard to secure finances for yourself. And what a shame it would be if you didn't secure those finances for after you're gone from this world. Because we know we can't take this stuff with us. But if you had the choice between seeing the fruits of your labor and giving them to the people you love versus seeing the fruits of your labor and seeing it enter the gates of a courthouse, of the government, of creditors, and then if there's anything left to your loved ones, I think we would all choose this option over here. So just kind of laying that out there too. Please talk to an attorney. Obviously, we at Plan 4 do this all the time. Depending on your assets and situation, it really does determine whether or not you're going to need a will, or you're going to need a trust, or you're going to need a land trust, or you're going to need a toady, or you're going to need a basic will. Illinois, as a practicing attorney in Illinois, there are lots of different options that Illinois provides its citizens versus other states. So when you're ready, it's a really great, I say great because it's fun for me. I enjoy this kind of stuff, but it really is a great gift to yourself, and it gives you a lot of peace of mind about, managing the fruits of your labor as you manage and protect them now, to be able to know that they can be managed and protected when you pass away. So just as a disclaimer, I am an attorney licensed in Illinois. I am not giving any type of legal advice. My sole purpose is to give you some education around revocable trusts. Today, we talked about revocable trust mainly towards an individual. We really kind of simplified the process. There are some caveats and nuances. Does get complicated is not the right word. But as a married couple, trusts do function in a separate way, in the sense that you could have two individual trusts if you so wish, or you can have a joint trust that then separates after death, depending on if you are a blended marriage, or if you're like a blended family, if this is like your second or third marriage, or if this is your first marriage, or there's lots of avenues to take. So yeah, it's a fun conversation to have. Don't shy away from it. You wouldn't shy away from protecting your money while you're alive. Why shy away from protecting it when you're gone? Feel free to link and subscribe if you want to hear more information about estate planning. Thanks.